Hello, and welcome to UK Employment Law, the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights recent case law and legal developments of importance to UK employers. It is presented by members of Mayor Brown's employment team and occasionally features special guest speakers who are involved in changes in employment law. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions. We hope you enjoy the podcast.
Hello everyone and welcome to the Mayor Brown Employment Podcast. I'm Chris Fisher and I'm head of the London Employment team at Mayor Brown. In this episode, we have two cases which are relevant to an issue that many of our clients are facing at the moment, and that is making arrangements for a return to the workplace as the current lockdown measures are gradually eased. Certainly, we've seen the various task force groups that the government has set up to look into what guidance they will be giving to employers and the public generally. For example, can an employer require evidence that employees have been vaccinated? Or can they put in place requirements for regular testing and evidence that employees have received a negative result before attending the workplace? And against that background, as I say, we've had two recent cases that are interesting. The first is Rogers versus Leeds laser cutting. This is only a first instance tribunal case, so it's not binding on future tribunal cases, but it's worth looking at. And Mr. Rogers was a laser cutter, which you might expect from someone working in a business called Leeds Laser Cutting. And he worked in a warehouse-style workplace with a small number of colleagues. There were only around 5 workers on the shop floor at any given time. The case arose in March 2020 when the first national lockdown was announced. The employer, in this case, kept the warehouse open on the basis that employees couldn't work remotely. They consulted experts and put in place various safety measures such as social distancing, wiping down surfaces, staggering start, finish and lunch times. Now, about a week after the lockdown was announced, Mr. Rogers said he would not be returning to work until the lockdown had eased. And the reason he gave was that he had a high-risk child who had sickle cell anemia and also a 7-month-old baby. As a result, his employment was terminated. Now, Mr. Rogers didn't have 2 years' service, so he couldn't bring an ordinary unfair dismissal claim. But he was relying on the provisions in the Employment Rights Act that sometimes allow an employee to bring a claim of automatic unfair dismissal without the need for 2 years' continuous service. And one of those grounds is where the employee reasonably believes that there are circumstances of serious and imminent danger which he cannot reasonably be expected to avoid. And on that basis, the employee refuses to return to his place of work. So the question for the tribunal was whether Mr. Rogers reasonably believed that there were circumstances of serious and imminent danger. The tribunal judge fully accepted that Mr. Rogers had entirely genuine and reasonable concerns about the COVID-19 pandemic and the potential risk to his family. The evidence was that Mr. Rogers didn't leave the house for 9 months. Critically, though, the tribunal said that this belief was not that there were circumstances of serious and imminent danger in the workplace. His belief was that there was serious and imminent danger all around due to the pandemic situation. And there was no evidence really put forward by Mr. Rogers about any concerns he had about the workplace itself or the measures that the employer had put in place to deal with the pandemic. So the tribunal concluded that Mr. Rogers' decision to stay off work was not directly linked to his working conditions. And that, the tribunal said, was fatal to the claim. So an interesting case, although, as I say, it's only first instance and it won't be binding on tribunals going forwards. And certainly you can see decisions going differently where the facts are different and employees do raise concerns about safety measures within the workplace. And then the question is going to be whether the employer reasonably believes that in spite of the measures the employer has taken, there are still circumstances of serious and imminent danger. So that's Rogers versus Leeds laser cutting. The next case is Vavrika and the Czech Republic, and this is a decision from the European Court of Human Rights concerning mandatory vaccinations and whether they were contrary to the European Convention on Human Rights. Now, this was not the COVID vaccine, and nor was it an employment context, but there is an obvious parallel with vaccination policies that governments or employers might look to introduce in relation to COVID, such as a policy of requiring proof of vaccination before employees are allowed to return to the workplace. The Vavrika case concerned a law in the Czech Republic which requires mandatory vaccination for children against certain illnesses such as hepatitis B, tetanus, measles, mumps and rubella. And the sanctions for not vaccinating your child that came up in this case were that for a preschool age child, they were then prohibited from attending nursery school, and for children under the age of 15, their parents or guardians could become liable for a fine of about €400. So the applicants in this case included Mr. Vavrika, who was a parent of 2 children who didn't receive the required vaccinations when they were aged 13 and 14. And there were other applicants bringing claims in relation to younger children who had been denied access to nursery school because they had not had the MMR vaccine. And the basis of the claim was that the Czech law was contrary to Articles 8 and 9 of the European Convention on Human Rights. Now, Article 8 is the right to respect for private and family life, and Article 9 is the right to freedom of thought, conscience and religion. So, what was the outcome? Well, firstly, under Article 8, the court accepted that the mandatory vaccination requirement was indeed an interference with the right to respect for private life, because it was an involuntary medical intervention. Now, although none of the vaccinations were in the end performed on any of the applicants in the case, the consequences that they suffered, such as not being admitted to nursery or being fined, were enough to constitute an interference with their right to respect for private life. But the court found that the interference was justified, and they gave various reasons, which included, number one, there was a clear and legitimate aim for having the mandatory vaccination policy, which was to protect against diseases which posed a serious risk to health. Number two, there was a general consensus within the European member states that vaccination was one of the most successful and cost-effective health interventions for children in relation to these illnesses. Number three, there was evidence that the Czech government had considered whether the vaccination policy should be voluntary instead of mandatory, but the strong view of their medical experts was that it should remain mandatory. And they were able to point to data showing a risk to public health increasing significantly if the vaccination policy were made voluntary. And that was particularly because of children who would be unable to be vaccinated for medical reasons and who were therefore relying on herd immunity as their means of protection. And lastly, they also pointed to the general view from the scientific community that the vaccinations in question were effective and safe, and they'd been in effect for many years. So all in all, the court concluded on Article 8 that the interference with the right to respect for private life was justified. So that left the argument on Article 9, the right to freedom of thought, conscience and religion. And the court rejected that argument fairly briefly. There was no argument by any of the applicants that their refusal to be vaccinated was based on any religious belief. So the question was whether there was a breach of the right to freedom of thought and conscience. And Mr. Vavrika's evidence was that his main motivation had been to protect the health of his children, because he was convinced that the vaccination could harm their health. The Czech government said that this was a subjective assumption and it couldn't constitute a belief for the purposes of Article 9. And the court agreed. They said that the belief had to constitute something of sufficient cogency and seriousness in order to fall within Article 9. And really here, the problem for Mr. Wawrzyka was, it seems, the lack of any substance to the evidence he produced on Article 9. His main argument was health-related, really, which was essentially his Article 8 argument. And the Article 9 point seems to have been introduced quite late in the day in the proceedings. So it's not surprising, perhaps, that this part of the case was unsuccessful. So that's Wawrzyka and the Czech Republic. As I say, it's an interesting case at a time when there is so much debate about whether governments and employers can impose COVID vaccination policies on employees, i.e., can you require proof that an employee has been vaccinated as a condition to allowing them to return to the workplace? And there are various considerations to take into account in relation to a policy like that. But the Wawrzyka case suggests that the human rights arguments may not be paramount among those considerations. But obviously the Wawrzyka case was specific to its facts, and there are some important differences compared to the COVID situation. The Czech law in the Wawrzyka case concerned vaccinations that have been in operation for many years. There were no obvious alternative measures to protect children from those illnesses, and certainly there was much more weight of scientific data to back up the effectiveness of the vaccinations concerned. The COVID-19 vaccine, of course, is not mandatory in the UK, and unless the government recommendation over the next month or so is for employers to require evidence of vaccination before allowing employees back to work, which I think is unlikely, then I don't think we're going to see many employers adopting a mandatory vaccination policy, certainly not for office premises where other measures can, and indeed in the past have been taken to combat the virus. What I think is more likely, though, is perhaps policies around testing of employees, where employers might require employees to undergo a program of regular COVID tests as a condition for returning to work. And the Wawrzyka case would suggest, as I say, that the human rights implications of a policy like that should not perhaps prevent it from being put in place. And as we see more and more workplaces opening up again, we will, of course, be monitoring the government reviews over the next couple of months to see what guidance flows from that. But for now, that's the end of this podcast. I hope you enjoyed it. If you have any questions or comments, please do let us know. And I look forward to speaking to you next time. Until then, I hope everyone stays safe and well. Bye for now.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Christopher Fisher, Head of Mayor Brown's London Employment Team, at cfisher@mayorbrown.com. Thank you for listening to the podcast.